Thank you very much.
Yes, Judge. Yes, Judge. I would like to begin by reading out a short statement. The pre-trial review is in the matter of CFI 029-2018 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Adolfo Goddard, Middle East LLP. Lead counsel is Tom Montague Smith, QC. The defendant is represented by Ahmed bin Dahi Advocates and Legal Consultants. Lead counsel is Roger Bowden.
Well, thank you very much. And if you're seeking my confirmation as to what you have just read out, you have it, and no doubt you have it from Mr. Montague Smith and Mr. Bowden too.
Your Honor, yes, I confirm it.
Now, the first thing I want to raise is this. Mr. Montague Smith, do you have any objection to this hearing proceeding, bearing in mind concerns that have been raised in the correspondence that arises from the fact that Mr. Bowden has joined the law firm that was originally acting for the claimant?
Your Honor, I don't object to the hearing proceeding. I would like to address you on it. I have some observations on it, and you will have seen my client's position, which is that we don't intend to ask for Your Honor for an order in relation to it, because the result of that will be that we'll lose the trial. We're placed in an impossible position. I would ask Your Honor, and I'll address you as I say, to make some observations about the way in which it's been dealt with by the defendant's lawyers, and perhaps issue some guidance, if I can put it like that, as to how it ought to be dealt with going forwards.
Yes. Right. Thank you very much. Now, because of those early noisy interruptions to our proceedings, I have come out of the e-bundle. So I want to just take a moment to go back into the e-bundle, if you'll bear with me, please. Right, can you hear me?
Yes, thank you, sir.
Right. I'm able to look at and use the e-bundle, but in doing so, I'm off the video screen, so to speak. But I don't think that matters. Now, Mr. Bowden, you're making an application, in effect, to strike out parts of witness statements on the basis that they are hearsay. Now, I've had a look at the witness statements, and unfortunately, when it comes to Mr. Buckley's statement, the highlighting is so faint I can't see which sections are highlighted and which are not. And so you will have to direct them to me. Now, I do want to say this before we begin this exercise. This is a rather extraordinary application that you are making. It's true that there are provisions in the RDC about hearsay statements, but in the main, they apply to classic hearsay, where a witness goes into the witness box and recounts what he was told by somebody else. You seem to be making objection about, for instance, findings made in internal investigations and the like, which I have real doubts are contemplated as being covered by the requirements to give notice, which are in RDC 29. So I will just make that introductory observation. Now, I'm very keen that this exercise is conducted briskly. I've read the statements, I've read the skeleton arguments. And so can we start, please, straight away with your objections to Mr. Beckley's witness statement, which I'm going to go to now. Which paragraphs are we going to?
The first one is 15, sir.
15. It was noticed by the chairman that under the administrative expense section of the list, there was a proposed payment and so on.
Yes. And might I say, sir, that this is really lies at the heart of my objection, is that the person who should be giving evidence in almost all of these hearsay statements, sir, is the chairman, and he's not. And so this is the problem here, is that party A, or witness A, is getting witness B and C to give his evidence for him. That's the nub of the problem here, sir.
Wait a moment. Yeah. It isn't hearsay for a witness from his own observation of a third party to testify that that third party, for instance, in this instance, had noticed that the expense section of the list was in that section there was a proposed payment of 610,000. And in any event, isn't it in effect common ground that the chairman, and it would seem Mr. Beckley, were focusing on this 610,000 as a matter for investigation? Now, I know you say that the motivation was a collateral one. They were bent on, in effect, punishing your client for having the effrontery of leaving the company. I understand that as being part of your case. But does paragraph 15 of this statement really get in the way of the court getting to the real matters in dispute?
Well, on our case, yes, sir, because there's nothing to say that it was noticed by the chairman. That's the point. There's no evidence as to, did he see the chairman notice it? How did the chairman notice it? What did the chairman say? So, and indeed, so when we go, and the list of expenses is further down the bundle, so I think it's document, I apologise. It may be, sorry, the document number 7, sir, and it's a line, I can take you to it if you like.
Well, just summarise it for the moment.
Yeah. Well, there's a list of hundreds of payments, all of which, this is a list which is put together by the finance department, and I will take you, I hope, later in the hearing to the actual documents themselves, so that we can have a look at how this list is put together. And it's a normal business record. And so if it's noticed by anybody that something is untoward and that this is suspicious, with respect, the person who has noticed it should be brought forward and be giving that evidence. They shouldn't be giving it remotely via somebody else. I don't know that Mr. Beckley knows anything about it.
Well, listen, I entirely understand your point.
Exactly.
The question is whether or not we want to take up time in striking out paragraph 15, when I understand that your case is that there is no evidence that the chairman himself noticed these matters. The court can take that into account.
I agree.
I
absolutely agree, sir.
So there'll be a transcript of this hearing, and you'll see you'll see the view that I'm taking. That I understand the doubt, serious doubt you raise over whether or not the chairman noticed it, and this can be ventilated at trial. Let's go on to the next. Let's go on to the next paragraph.
Again, sir, I won't repeat myself, but Mr. Fadil was asked for more details by the chairman. That's classic hearsay, sir. He wasn't even a party to the conversation, as well as proof of payments. The next one, sir, we're at 18.
Well, Mr. Fadil, wait a sec. Mr. Fadil will deny that and say that he wasn't.
Yes, he will, sir. Yes, that's correct, sir.
All right.
Wait
a sec. So do forgive me. And so there'll be an issue in the evidence as to whether this occurred, what is said in paragraph 16. I will hear directly from Mr. Fadil. I won't hear from the chairman, and I'll have to take all that into account in deciding what happened.
I agree, sir.
Right. Let's go on to the next paragraph.
If I could just say one thing. I look at this in terms of how are we going to prepare for this hearing, and it's going to be a little bit like wading through soup. I will be putting to Mr. Beckley in relation to that paragraph, I think we're on 16, that you weren't a party to the conversation, were you? No. This person denies that it was ever said. Well, he'll say, well, the chairman told me, and we'll just waste hearing time, sir, going through very low value evidence.
Well, I think we can take it really pretty briskly, quite honestly. You're an experienced advocate, and if I may say so, I'm an experienced judge, and we're not going to be bogged down in a great bowl of soup. I can assure you of that. Right, next paragraph.
18, sir.
Yes.
Following the conclusion of the internal audit, Mubarak Taj. So this is a reference to the report of Mr. Taj, sir.
Yes.
So that is itself hearsay. Mr. Taj hasn't been called as a witness. I think my learned friend is conceding that he's not intending to call produce the internal audit report as proof of its contents. And if so, that does take some of the sting out of my criticism. Other than that I would say that these witness statements collectively demonstrate, no matter what he says, an intention to do exactly that, i.e. rely on the internal audit report as proof of its content, i.e. that there was a fraud, or even that there appeared to be a fraud. We say, well, look, we've got our own hearsay evidence in relation to this document, and that is that it was entirely contrived and brought about by oppression against the putative maker of it, sir. So, I think that the two sides are well understood and well understood by you, sir. But my objection is to this, sir. Following saying that Mr. Taj did anything, sir. If we're going to say that, Mr. Taj should be here.
Well,
I say the same thing.
Wait a sec. What is said here is that Mr. Taj wrote to the chairman. Now, did he write to the chairman?
I don't accept, sir, that he did, other than to say that his signature was obtained on that document by oppression. set it out in the skeleton as to how this is said to have happened. Mr. Taj was himself, for a brief time, the director of finance of this company. So therefore, he was approving some of the impugned transactions, sir. And it said that Mr. Beckley and Mr. Jabera and the chairman knew this fact, knew that that was actually a conflict of interest for an auditor to be auditing his own transactions, and used that to say to Mr. Taj, this is what Mr. Taj told my client, sir, that if you don't sign this, we're going to say that you're the co-conspirator. It sounds a credible narrative to me, sir.
Okay, I understand that.
That's my objection. Yeah.
I understand.
19.
Yes, 19.
Same objection, sir. Well, that really relates to the internal audit documents. I'm not sure about WB 240. Sounds like a weed killer that we use on the farm, sir.
What has happened is this, isn't it? That there was a report.
Yes.
Now, and the existence of that report is a fact that can be proved simply by putting in the report. The question is it evidence of does it prove the misconduct which is identified in that report?
Yeah.
And again, given your client's evidence about it, you can take it from me that this question will be a live question at the trial. So, so far, I'm giving you a series of assurances, and I'm not going to strike these things out. Now, let's go to the next paragraph.
And I take no issue with that, sir. But I feel duty-bound to raise these things, and that there's going to be something of a collision come trial time about this evidence.
Well, that's fine, as long as we deal with this expeditiously today.
Absolutely, sir.
It may well prove to have been a useful exercise, simply highlighting something which is going to be an important issue at the trial. Okay, let's go to the next paragraph.
That's 21, thank you, sir.
21, yeah.
And about that, I say, well, of course, this is reliance upon the Ernst & Young report.
Yes.
It hasn't got the same problems as the internal audit report. The maker of that document's not being called. I think on this point, my learned friend explicitly concedes that he won't be relying upon the content of that report as truth or as proof of its content. However, the difficulty is that these passages in the witness statement, and there's many more that are much worse actually in Mr. Jabera's witness statement, they do that. They do purport to rely on that document as proving the contents of it, and that's the problem. It's all very well for my learned friend, and of course I accept what he says, but to say that he won't be, but they are. His witnesses are, sir. That's the problem. Thank you.
Next paragraph.
Next paragraph, 23, sir, and that would be the second sentence in 23. I apologise. I'm looking at a document which doesn't seem to have those highlighting either, sir, but it was there when I loaded it. I don't know what's happened, and I apologise for it.
Not to worry.
Yes, second paragraph, Mr. El Fadil was always required to obtain approval before processing. Well, again, sir, there's no direct evidence of that. We've asked for that evidence, hasn't been produced. I'd object to the giving of it in this manner. That's the point. Next one, sir, is 28.
Yep.
And I'm sorry, sir. Right. This is the reference. We've got an amorphous outfit or body, sir, called the group. Really, sir, the group equals the chairman. And so both of these witnesses, they refer variously to the group, we, us, the company. What they mean, sir, is the chairman. and this is really an attempt to avoid giving hearsay evidence by attaching himself to the group. He doesn't say who the group are, what the opinions of the people within the group were, and he particularly doesn't say it was his own opinion. Of course, I'll cross-examine on exactly that point, sir. So that's my argument.
Okay.
There's 29.
29, yeah.
It's the same objection, sir. Following discussions with external advisors at the time, the decision was made. This is obviously hearsay. He doesn't say he was a party to those discussions, what those discussions were, where they might be recorded, or anything of that nature. There's also, sir, a complete waiver of privilege. Right. Next point, sir, would be 34.
Yes.
It was the groups and he does do that. I'll concede that point, sir. The Mr. El Fadil was not entitled. He was refusing to cooperate with inquiries about the matter. Again, sir, that's hearsay. Unless this witness is able to say, I asked him, he had been asked on A, B, C, D, and you will have seen, sir, that we're seeking this information under document production. When did you, if he was asked so many times between January, February when this matter arose, January when it arose, and May when you dismissed him, where's the evidence of that? And you can't, in my respectful submission, just bring it in through the back door with some sort of vague hearsay averments such as this, that he was refusing to cooperate. There's zero evidence of it, and it is, in my submission, sir, it does amount to hearsay. If he changed it all to I felt this, I felt that, I had asked him, he hadn't replied, it would be different, but it's not, sir. The group's concerns may well be legitimate. What respect does that mean?
Okay.
We're down to 40 on this witness statement.
40. Yeah.
Because again, sir, that this is the hearsay assertion that Mr. El Fadil refused to engage with the group. And I accept everything we've said before. This is cross-examinable, and it will be, sir. Okay. That would be number 3, sir. If we move briskly along to number 4.
Yes, this is Mr. Jabara.
Yes, this is Mr. Jabara, sir. And this is his witness statement. This would be his evidence in chief of the 20th of June.
This I thought I could possibly discern some highlighting. Do we begin at paragraph 29A? Or is this beforehand?
Sorry, sir. We begin at 25.
Oh, we begin at 25. Fair enough. Okay.
Yeah, I apologize, sir. I did this on Adobe, and one thing I do know, and that is why I produced the report in the way that I did via my submissions here, is that Adobe and case lines are not friends. And we'll come back and work on it, sir.
All right, okay. So we're at 25, yes.
Yeah, here's another reference to this internal audit report. That KJ 45253, sir, that is the reference to the internal audit report.
Yes.
So that's where we found. 16, which were unauthorized, etc. So I say that's entirely hearsay, sir. We move on to 28. By way of a handover, that's not sentence 2, sorry, my notes say. Although Mr. El Fadil was informed that the list was wholly inadequate, again that's hearsay, and asked to provide detail, he then failed to attend work from 24 April until his resignation. So it's that second sentence, sir. Although he was informed that the list was inadequate. Thank you, sir. Moving on, 30.
Well, what about 29A? That seems to have been highlighted.
Oh, it does indeed. My apologies, sir. Yes, the discovery of the unexplained attempted payment of, well, again, sir, that's hearsay, unattributed hearsay, really, sir, is what it is. Who discovered this?
I apologise for interrupting. The colour of that highlighting is actually different. As I'd understood it, the colour coding, there's an allegation that these were unpleaded, not that they were hearsay. We dispute that, but that I understood was the allegation in relation to 29A to C. The preamble, it said, so that the first two lines were said to be hearsay.
All right. Okay. Well, I can take that on board at the trial, whether or not this evidence goes to a sufficiently pleaded point. Fine. Next paragraph, Mr. Bowden.
Yes, thank you, sir. That my learned friend is correct about that, and I apologise. I've now got a colour-coded list before me, sir. 30. Again, there's a reference to the internal audit report, sir. So that's wrong. That is hearsay, sir.
Yes.
We've got 31, sir. Sentence 1 is hearsay. I'm aware, again, as a result of the highly concerning findings from the internal audit. Again, that's hearsay, sir. We've got 33. Now, this is a problem, sir, because this hearsay. Not only that, sir, but this hearsay is actually contradicted by the document that it refers to. Having appointed an experienced auditing firm to conduct the report, it was not us to dictate. However, by the time they went to speak to Mr. El Fadil, he'd left the group with company property and not returned. Due to the ongoing police proceedings, given his failure to engage, we told EY they should proceed with the preparation of the report without Mr. El Fadil's input. Now, of course, sir, the report itself at internal page 9, what that simply says is we were told not to speak to Mr. El Fadil about this matter. So not only is it hearsay, sir, but it directly contradicts the document which it purports to rely upon. That's my problem with that.
Okay, all right. Well, that's clearly a matter that I can take on board at the trial. Do go on.
Yeah, 34, sir. Yeah, this is just direct reliance, sir, upon that interim preliminary report. And it's actually, sir, this is a reference. KJ 464 is a reference to the EY report. And so, again, it's reliance upon a hearsay statement. I'm saying 35, it's exactly the same, 36, 37, 38, it actually switches, sir, and as evidence of the to justify this dismissal, this document, sir, purports to rely upon the dismissal letter itself. So it's entirely circular, sir. It says, well, that Mr. Fadil sought to personally benefit from lack of proper procedures. Now, these are quotes, sir, which are lifted from the dismissal letter itself. And so in order to justify the allegations which are made in the dismissal letter, this witness relies upon the dismissal letter.
Well, wait a minute. I mean, the dismissal letter may be reflecting the findings of the interim report. Now, I know you dispute that those findings are good findings, but on the other hand, if there was an interim report which set out certain findings, and if in your case you'd say a big if, and if those findings were genuinely relied on by the claimant, then there wouldn't be hearsay would only go to the question as to whether or not there really was an entitlement to rely on those findings in dismissing your client. I mean, if a consultant comes in and makes an absolute hash of an investigation, but the client who engaged the consultant takes the view, well, we've engaged an expert consultant, they've come to this conclusion, and we're going to act on it.
Yes, sir.
Now, of course, in certain jurisdictions, there would be a question about implied terms in the contract of employment and whether an implied term of good faith would require, or what it would require in terms of coming to a decision on the basis of a report. But it wouldn't be hearsay evidence that the report was commissioned and the report made certain findings, and that these were genuinely relied on by the dismissing employer.
Absolutely, sir. All I would say is that he's actually relying on a report which was authored by and signed by Mr. Beckley, and so I guess it does remain hearsay. But yeah, I think I've made my point there, sir.
You've made your point. Let's carry on.
Yes, exactly, sir. So that was 39. Well, 38 and 39, same problem, sir. Both quoting. And 43, sir. Yeah, sorry.
Yes.
Yeah, again, sir, this is reliance upon hearsay documents. He doesn't actually attribute the hearsay to which he's speaking of, sir, but it's a reliance on hearsay documents. Yeah, that's it. Thank you, sir.
All right.
And in relation, the next one that we would be coming to, sir, is 44A. Yes. Now, A, B, C, D, E, and F. Now, they are, as my learned friend points out, this faint colouring we've got there, yeah. Sir. This is the repleading. Now, sir, I think a pleading is the facts upon which one seeks to rely. Evidence is anything which seeks to prove or disprove the facts in issue. These statements here, they do nothing, sir, to prove anything. They're just statements of fact. So they're not. They just don't qualify as evidence. That's my point about that, sir. Simply don't qualify as evidence.
I'm not quite sure I've understood that.
Oh, okay, sir. Well, if a pleading, sir, I say a statement of claim or a statement of defence, is a distillation of the facts upon which a party wishes to rely, yes. Right? And evidence is anything which goes to prove or disprove a fact in issue, right? These are not evidence, sir, because they do not seek to prove or disprove a fact in issue. They're just statements of fact. They don't seek to establish or disestablish that fact.
Well, as I read this, what the witness is doing is setting out issues relating to your client's employment. In other words, he's saying that as far as we were concerned, in the way we were approaching this situation, these were the issues that we we saw. Now, he's entitled to say that. Whether or not that was soundly based, that those issues were soundly based on what had really happened, is a separate question. So I don't think there's too much trouble about what's said in this paragraph. Yes, for pleading is an evidence, but this, I think, is on its face not obviously contrary to the usual rules and conventions, and you remain entitled to challenge, if you like, the underlying facts, which on the claimant's case gives rise to the identification of these issues. So let's go on. Then we've got paragraph 45.
Yes, sir. Same problem, effectively.
Yeah, okay, understood. Well, I've dealt with that. And I think Is this the same throughout this long paragraph 45? Really?
Yes, sir. We can skip that.
Okay, we can go on.
That's what I'm saying about it.
Yeah. Okay. I understand. Yeah.
Allegations. Okay.
All right. And now, is there anything else?
It's valueless.
All right.
That's
okay.
the price of admission.
All right. Fair enough.
Thank you. 45.
Yeah. All right.
I think that's
well,
past 45. 46.
Yes.
Again, we're back into unattributed hearsay. It's not proof of these allegations. It's just a rehashing of something he's heard elsewhere.
Yes. All right.
46, 47. Well, that's entirely conclusory, and it doesn't say anything about his involvement, whether he decided to do it, who decided to do it. The chairman decided to do it. It was nothing to do with this man. But here he is, boldly saying that this happened and that happened. He in respect, sir, there's no evidence in here that he has a clue as to what occurred. 48, sir. First sentence is hearsay, that there was a misappropriation, that there were any serious dereliction of his duties. I accept that this is actually admissible opinion, but it is hearsay. But this is the type of opinion which is allowed, and that is opinion is I saw, I smelt, I did, and so yeah, I accept that the opinion that he expresses there is okay. 49A and C, sir, I had indicated were a repleading. Again, it's a statement of fact. There's no effort there to prove or disprove any other fact. 50, sir.
All right. Now, is there anything under the? I've come down to paragraph 56.
Yes, sir.
And there's complaint made of the last sentence about the Dubai public prosecutor.
Yeah, and I think
the belief as to why that happened.
And I think my learned friend went close to conceding that this is opinion. He doesn't think it matters, but of course Your Honour might have a very different view. It's for you to form these views, sir, as to whether it was reasonable to take it to the police. If we come back to 50, sir, this was an entirely reasonable course of action to take. That's entirely conclusory, sir. And it's not an opinion that this witness is able to give. It's not smelt. And 56, sir, is certainly objectionable. We have no idea, sir, what the police rules are, internal regulations are for accepting complaints. They might accept every complaint that comes across their desk.
Forgive me.
Yes, sir.
You make an obvious point, and
yes,
this is something that is going to emerge at the trial and will be dealt with accordingly. Now, look. Help me with this, Mr. Bowden. You've seen the general trend of my reaction to your to your objections, and are you prepared to accept that in respect to any further objections you might make to this witness statement, and as to the reply witness statement, which is number 5, are matters that the court will be alive to at the trial? I mean, for instance, you could in your opening have an annex where you annex these statements and you highlight them to remind the court of the line that you're taking at this PTR.
Yes,
what I'm keen to do is I've been with this case for really almost since it began, And what I'm keen to do is to have a trial where we get to the things that really matter.
I completely agree, sir.
I don't want to take up any more time looking at these statements, because I am confident that any of your concerns can all be dealt with expeditiously at trial. There'll be a few questions, to highlight the lack of probative value of what's being said, and you'll make your submissions accordingly.
Yep, I agree, sir. I raised them in order to save time at trial. I don't.
Well, you may have saved time at trial.
Yeah.
By this exercise that we've undertaken. Now, let me just break off for a minute. Now, Mr. Montague Smith, you've seen the line that I'm taking here. I'm leaving all this in the basket that comes up at the trial. Do you have any submissions to make to suggest that I ought not to take this approach?
The only statement that I would draw your Honour's attention to is the statement of Mr. Syed, and it might just be worth your Honour considering whether or not to take a position on that now. You'll find that at page 640 of Bundle 6.
Well, which numbered item is it in the list of things in the left-hand column on the?
I'm going to find that for you. I'm so sorry.
Thank you.
My notation is by page number, so
yes, I see. Well, I could put the page number in, I suppose.
It's number 38. It's number 38, sir.
Thank you very much, Mr. Howden.
Okay, yes, Mr. Tyre, right.
So the only reason I raise this with your Honour, the only reason I raise this with your Honour is it might well be that we can dispense with an entire witness at this stage, because Mr. Syed was the expert who was appointed by the defendant to produce an expert report.
Oh yes, I remember.
What's happened here is you've got a witness statement from the expert exhibiting his report. So it's a witness statement. So it's an expert report effectively dressed up as a witness statement, which is a situation where this court has previously intervened in evidence in advance of the trial to save time on preparation. Because if I need to cross-examine an expert and your Honour's in effect admitting expert evidence, then a question will arise as to whether there ought to be an expert in response and so forth. So if your Honour looks at paragraph 5, for example, you'll see he's shown the report that we'll start with. He deals with 3. What he's asked to do, he's asked to review the transactions and to provide an opinion.
Yes.
And then 5, he produces that opinion.
Yes.
And then 6, he summarizes the opinion.
Yeah.
And 7 as well.
Yeah.
So and then he exhibits it. So all that this witness is doing is exhibiting an expert report. Now there was permission for experts, but it's obviously to be parties were to avail themselves of that in accordance with the court's direction, so everybody knew where they stood in relation to experts. So I completely understand that your Honour's an experienced judge, is able to look at this information and determine what value, if any, it has at trial. But it does potentially lead to a dilemma as to how the claimant deals with it at trial, whether it needs further evidence, whether it needs to really engage the court's time in cross-examination. Your Honour may or may not recall one of Your Honour's first cases in the Court of Appeal was a case called Fidel and Felicia, and that was an example of a situation where a party had done exactly this. They had produced on that case an expert report on UA, and the judge had struck it out, and that's a case that's in the bundle. So I'm in Your Honour's hands as to how you deal with this. I mean, it may simply be that if Your Honour accepts the principle, which is in the rules, which is that expert opinion needs to be by way of report, and it needs to be controlled, so there needs to be permission for it and so forth, and that this infringes those provisions, then I won't have any questions for this witness at trial, and we don't have to provide for him in what is going to be a very tight timetable.
Yes, it is a tight timetable. Well, imagine that the witness statement simply read, I am so-and-so, so-and-so, this is my professional experience, here is my report, full stop. The question then would be, well, was leave given for expert evidence? And what controlling measures should the court impose, because we're in the ballpark of expert evidence? Now, I think Mr. Bowden, other than what characterization do you give to this evidence? Is it expert evidence?
I don't believe it is, sir. I think it fits more in the grounds in the realm of a contemporaneous document, because this involves, I think, jumping a wee way through my submissions. But what the report purports to prove is that the 610,000 was properly payable to Mr. El Fadil. It actually proved a slightly bigger number. Well, I've explained that in my skeleton. And it also proves that the 1.3 million from the year before was also owing to Mr. El Fadil, and I think in passing dealt with the 1.4 from back in 2013. Now, all of that is accepted, sir. And my learned friends' witnesses have themselves placed reliance upon this report as establishing those facts. So I'm not raising this report, sir, to prove those matters. They're accepted. What the forensic value of this report is, sir, is in the annexures, and I've spent some time at the tail end of my skeleton, and we can go there right now if you like, sir.
No, thank you very
much. Having a look at that, and what it establishes, and this is the key point. And when we were on Mr. Jabira's reply witness evidence, sir, I was going to take you there to the 6 occasions when he says that we didn't find out about back up. He says, we accept that the 610,000 was properly payable to Mr. El Fadil, but we didn't find out about that until October. Well, what the report, Mr. Syed's report, does, sir, is prove to a greater or lesser extent that those documents the documents which would have established his entitlement to the 610,000 were available all the time, i.e. from January 2018, in the finance department, which is 2 doors down from where Mr. Jabira and Mr. Beckley were sitting. That's what it establishes, sir. It establishes something else. It's not really an expert report at all.
Well, I think the approach should have been a notice to admit the matters that you wish to rely on in this report, and then by reference to, not by reference to the conclusions that Mr. Syed came to, but by reference to the materials that he relied on to prove that case if the admission isn't made. So, for instance, you might cross-examine some of the claimant's witnesses on the basis of the information contained in Mr. Syed's report, without going to his final opinions and conclusions.
Okay. Well, can I just answer it this way, sir, just by reference to the evidence, because I did prepare on this exact point, sir, and that is, apologise, if I take you to document number 5 in the bundle, sir, because I accept what you're saying, that a notice to admit would be an appropriate way to proceed here. But what I'd also say is that it is admitted. So if you were with me, sir, at bundle document 5 and bundle 6, it's page 6 past 62.
Yes, I'm there.
Okay, if we go down to paragraph 33, sir.
33, yes. Wait a sec. Yes. Go on.
Now, should be 33. Should refer to October.
Well, I'm looking at 33 in item 5.
Yes,
Paragraph 33 of Mr. Jabber's reply witness statement. That's what I'm looking at.
Yeah, the 5th witness statement of Mr. Jabara, and it is dated the 4th of July, sir. That should be right.
Yeah. Yeah.
And paragraph 33, exactly as I said, I just wasn't reading it. My apologies there.
Yes.
It says, but he did not do so until October 2018. However, so it's that second sentence in the paragraph, sir. I believe the chairman said this because he expected, but he did not do so until October 30, 2018. If we go down to 41A, sir, and he is probably one of the better ones.
Yes.
41A, the EMA Saxon report presented has subsequently shown that the payments he was asking to be reimbursed were made 6 or more months previously. Yet there is no mention in the narrative of the blah blah. Okay, all right. But again, sir, it makes this point that this EMA Saxon report is correct, accepted as being correct. 46, sir. We do the same thing again. To be clear, Mr. El Fadil did not present any coherent evidence until the EMA Saxon report in 2018. And then we're at 47, actually repeats the same thing too. And then we've got 51, same thing.
This is all springing from Mr. Syed's report.
Precisely, sir.
And there's no doubt that on the pleadings and in the proposed witness statements, that the claimant accepts that having had the opportunity to see this report, they have concluded that your client was entitled to be reimbursed. Mm. That's a given in this litigation. Mm. So do we need anything else than that?
Well, yeah, as I've, I think, gone into an hopefully exhaustive detail in my skeletons here, and I'm not sure if you had a chance to look at the report and go to the bookmark sections. But what it does, sir, is comprehensively establishes that this information was available. Well, it proves, sir, the annexures to this report prove where that information came from. So where the information that these gentlemen claim that they only became aware of in October 2018, what Mr. Syed's report does, sir, is establish that that information came from the finance department, where the reports were, the bank statements, the invoices, whatever evidence there was checked, verified, and there's a stamp that goes on it, sir, which is set out in those documents. And the accountants, the general accountants, and that's Mr. Jitesh Raghavashi, sir, who's giving evidence. He stamps it, he signs it, and he books it onto the system, and that's how it gets there, sir. And so, that's the evidential value of the report. What it says about whether money is owing or not is accepted, but what's not accepted, it appears, is that this information existed under the noses of these witnesses the entire time. That's the real value of the report, sir.
Well, if it is manifest from looking at the report that the report is based on documents and materials that were within the finance department and would have been within the finance department from the time of their creation,
yes, sir.
Then you have your point.
Yes, sir. I need the report is the most.
You can. It seems to me that the report can go in not as evidence of opinion, but it can go in as a identification of available documents that led to the opinion.
Yes.
But that's my view at the moment. But I want to hear from Mr. Montague Smith about that proposed approach. What do you say, Mr. Montague Smith?
Yes, I agree with that. My main objection is in relation to Mr. Syed, because I think once Sean has made that, taken that view of the report, then one can see no need for Mr. Syed at all.
Yes. Well, Mr. Bowden, the report comes in.
Thank you.
It doesn't need a witness statement to bring it in. It's there, it exists. And you can deploy it in the way that I have suggested, not relying on the opinion, but relying on identification of documents that led to the opinion. And there's no need at all for Mr. Syed to give evidence. It's his report we're interested in and not his opinions.
Thank you, sir.
All right? And where are we?
Your Honour, you were asking me about whether I had any other observations about the evidence. And I mentioned Mr. Syed. There were one or two other passages in the defendant's seventh witness statement which do effectively the same thing. If Your Honour's happy for them to be treated in the same way, then that will be a solution to these points as well.
By the same way, do you mean how I've been dealing with what Mr. Bowden says is hearsay, or how I've been dealing with this expert report?
With his expert evidence, because what happens in his seventh witness statement is that the defendant says, I instructed some experts and they reported as follows. And so if that evidence is to be received simply as evidence of the facts that he states, rather than evidence of the truth and accuracy of those opinions, then that is perfectly fine. But if in effect what it's seeking to do is import again expert evidence, then it becomes problematic once more. So there's a few very short passages.
Well, let's look at them quickly.
So very quickly, and I don't want to burden you on it. It's in bundle 6, tab 34, page 640.
I'll go by page 640.
Correct. Yes.
All right. Wait a sec. Page 640.
It's paragraph 156.
Oh, wait a minute. When I put in 640, I get up something that says master 6-40. Is that the page?
Maybe it's 6-640 you need to put in.
-640.
Could be.
6, I think, space dash 6 space 640.
Oh, okay. 6 dash space 640.
I might have got that. I got that wrong, Mr. Montague-Smith.
Yeah, I mean, perhaps it's best if I make the submissions at this stage. Thank you, Mr. Bowden. So it's 6-640. Thank you.
6-640. Well, let's see what happens.
My apologies.
6-640. Fine page. Yeah. Okay. Fine. I'm there, and I can see the highlighted parts. Right. Let's go on.
So it's at the bottom, paragraph 156, and you'll see reference to the E-Sexena report, and provided a report which established that I was innocent of the charges. So you'll see what's happened is these expert evidence is being introduced in this way. As long as we have the indication from Your Honour that sort of evidence will be treated in exactly the same way as the report itself, in other words, evidence of the fact of the report, and not of the opinions that are stated in it, then it's not going to cause us a problem. And shall I show you the other bits where this happens, and then Your Honour can make a decision.
Yeah.
6-643 is the next one.
Wait a minute. 6-
It's only 3 pages on.
Yes. Okay. Yes, I'm there.
Paragraph 166.
Yes.
This is dealing with a different expert report. The expert report dated 24th April 2019 established that I did not take the money and that the claimant knew why I had paid out the money. So again, you'll see there's exhibited to that supplementary report of various people. So you've got the same one.
Yes, I see it. Well, what the defendant can say is that he commissioned the report. The report was provided to the claimant, and it's a fair inference that it was in the light of that report that the view was taken that he was entitled to reimbursement.
That's a slightly different report. That's the one that was produced, I think, in the context of the criminal proceedings in July. But there's two other references to that sort of evidence. One is over the page at paragraphs 169 and 170, which deal with the complementary report of the expert.
Oh, I see. Yeah.
And then also, if one goes forward to the next page, paragraph 172 to 173 is the findings of the public prosecution report, which again, the fact of the dismissal is not a problem. The fact that was the conclusion, but it's simply seeking to introduce those conclusions on opinions as evidence. So it's all the same point. I think if Your Honour is happy to deal with it in exactly the same way as the Sexena report, then it doesn't cause any problem going forward.
Yes, I mean there can be direct evidence that such a report was produced, and it contained these conclusions because that's what it did contain.
Exactly.
But the report in and of itself does not prove the conclusions come to unless we're in the realm of expert evidence, which at this late stage we can't be. And it seems to me it's given the real role that these reports played and the view that was eventually taken that the 610 and the 1.3 million odd were reimbursable. There would be little point in having the reports in as expert evidence.
Correct.
Save only for Mr. Bowden's point that he wants to be able, if necessary, he wants to be able to demonstrate that the materials that gave rise to the opinion were available, if you like, at all material times.
Right.
In the contents department.
Of course.
All right. Well, that's my view. I think you both follow it and understand it.
Thank you.
Now, where are we now?
Sorry, sir. Can I just say one thing? And that is, I don't want these reports completely fenced off, because of course, what proves the conclusions of the EMA Saxena report? It's not necessary to rely upon the report itself to prove the conclusions, because as I've just pointed out, sir, the claimant's own witnesses accept the conclusions.
That's fine. That's a perfectly sound point that you can make, and I'm alive to it. I'm alive.
Thank you. Nothing more to say.
Right, okay. Now look, we're already been an hour and 5 minutes. A PTR, this is a very extraordinary PTR. You know, we really ought just to be taking stock of whether everything's in order for the trial. Now, what else is left on your list, Mr. Bowden?
What else is left on my list, sir? Well, I think we've dealt with the report, and there's no need, the Saxon report, and that was a big part of it, sir.
Yeah.
We've dealt with all of the evidential matters. We've dealt with the objection to the. I'm at the front page of my skeleton, sir, which has got a little checklist.
Skeleton. Yeah.
Yeah. I'd like to. I think we should go to document production, sir, and the KPMG report. The point, my learned friend has agreed now to do a document production statement, and that is, you know, well overdue. What was produced, nothing to do with my learned friend or his instructing solicitors, I hasten to add, but what was produced in March was risible. So if a proper document production statement is now produced, and say, I'd like it within 7 days. We're 5 weeks out from trial. We really need to get moving on this, sir. It should have been done a long time ago. So if that's able to be done, that would be great. But in the meantime, sir, and if I can go to page 10 of my submission, my reply skeleton, sir, where I've set it out there, and deal with document production. Attached to the.
No, it's my fault, but I hadn't picked up that you'd served a reply skeleton. I've read the skeleton that appears high up in the order of items. Which number is it in the left-hand column of the e-bundle?
Well, I thought I had added it yesterday afternoon, sir, but I'm not seeing it myself. I had filed it via the registry, sir.
Well, you're going to have to summarise it briefly. I mean, what's the point here?
If we go to the original one, it's the same point, sir. What we want, what we've been asking, is set out in the application as well, so we can go to that.
Yes, I've got that. Yes.
Go to the application. That's document number 1, and then point 4 of that. So that's page number 6-2, sir.
Yes. Okay.
Right. So I want the electronic copy of the internal audit report, sir. Okay. So I want the original Word copy of that, which shows who the author was, because you would have seen, sir, the evidence of the defendant. And that is that he's spoken to Mr. Taj, and Mr. Taj told him that Mr. Beckley wrote it, and that it was all written by Mr. Beckley, nothing to do with him. He just signed it because he was strong-armed to do so, in a way. So this is a document, sir, which must be either on the personal or then work laptop of Mr. Beckley, which I assume he still has, or otherwise, sir, it must be on the server. And this is a large organization which operates a server. Now, this document just hasn't come forward, and it should. And if it did, it would show who created this document in the very first place, and all the revisions which occurred, and who wrote it. Problem solved.
Have there been the service of Redfern schedules identifying documents sought to be produced, and a response from the claimant, and then if claimant doesn't agree, an application to a judicial officer for an order?
Well, the background, no, sir, the background to this is that the internal audit report was never provided in the claimant's list of documents. It hasn't been cited prior to the 20th of June. That document had not been produced, referred to, or anything like that. The defendant said,
you knew it existed.
Yes, that's right. I was just coming to that. So the defendant says in evidence he did know of its existence, but if no one was relying on it, well, what's the problem? It was only, we're not relying on it, sir. it was only upon the service of the evidence on the 21st of June that we became aware that the claimant was planning to now, at the last minute, it's not pleaded, was planning to place great reliance upon it as justifying what it did. And so that, sir, has propelled this document into, front and central relevance, sir. And we want it.
I understand. That's A, and that's number A. Now, what about B?
B. Well, B, sir, is now the evidence which is, and I apologise for the skeleton which I referred to, but the EMA Saxoner report. What happened, sir, with the EMA Saxoner report is the the papers came in, sir. The invoices would come in. They'd go into the finance department and they would be stamped on the EMA Saxoner report, right, with booked. And then they would be signed, sir, or initialed by the general accountant. And then, sir, they would be photocopied, or a copy would be taken, and it would go into an lever arch file, which would be on the wall behind the accountant's desk. And that's pretty common, I think, with most business systems. We want that file. That is the file relating to Villa Rotana, sir.
But why do you need that? I mean, in the end, it was decided that your client could be reimbursed for it.
Well, that's not the point, sir. The point is, we say that this entire business of the claimant, this entire business that the defendant was not entitled to any of this money, right, is completely untrue. That's what we say, sir. And not only was he allowed access to this material, not only was he entitled to reimbursement, but that it was processed by the internal finance department of the company in accordance, on many occasions, the direct instructions from the chairman. So that is it, sir. And all of the evidence for the 610,000, right, is in that file. And the evidence will be that file was well known to everybody and always in existence.
Yes, okay. I've got that point. Now, what about C?
C. Well, the claimant, sir, has said, and we've been through it in my hearsay objections.
Yes, yes, I see.
Many times we asked him. There doesn't appear, to my knowledge, sir, to be one single written request that he do so. So it really, sir, is it's a belts and braces approach by me.
Yes, I understand. And what about D? What's D about?
D.
The witness statement of Khalid Jabra.
Well, there were two, and this, sir, goes right back to the filing, sir, of the or the failure to file a statement of defence and filing of a acknowledgement of service on the wrong file. There were two separate files here, sir. So the first one was 024,
yes,
and then there was this one, 029.
Yes.
Now, in relation to the ex parte orders obtained under 024, there is in existence, there must be, a witness statement, which referred to, of Khalid Jabra dated.
It must be with the registry, mustn't it?
Yes, sir.
Well, have you asked the registry for it?
No, I confess that I haven't. I've asked the vendor for it. The claimant for it, and they haven't provided it. But I can go to the registry directly. No,
actually, that's not in fact accurate. It has been provided. It was provided in March by the claimant's previous solicitors, Kane and Associates. There's also an order actually permitting the defendant to access the registration system, the registry's system, to retrieve any documents that they want. We've actually now located again the new legal team. We found it in the file that was sent to Mr. Bowden. We'll send it to him again.
All right, that's D.
Okay, well, I'm about to be embarrassed. Yes.
Now, are we also looking at number 5? Any report, letter, memorandum, blah, blah, blah?
Yes. Now, this is a pretty interesting one, sir. Now, there's what is set out in the witness statement of Mr. Jitesh Raghuvanshi, sir, is he says, and I'll just go to it if I can read it out, or otherwise we can certainly.
Yeah, just read the gist of it, would you?
Yes. Sorry, sir. Go back one page. What Mr. Jitesh Raghuvanshi says is this, sir. After I left the company, within a few months, I was called to the office by Mr. William Beckley, the General Counsel of TIG, and he was joined on by a team from KPMG who explained to me that they were reviewing the transfers made to Mr. Abdelazim. I explained to them that the payments were reimbursed to Mr. Abdelazim and respective payments which he made from his personal bank account on behalf of TIG. Now, despite the very unfair criticisms from my learned friend made about me, this was the first that we knew of this. And we wrote a few days after Mr. Raghuvanshi had told us this, sir, and asked the claimant, what's this about? And they said, well, there's a report, but it's privileged. Now, we don't accept that any privilege can attach to this document, sir. It's said to be litigation privilege. Well, this might be, I want to cut to the chase here, sir. If, as my learned friend has indicated that he will produce or create a document production statement, right? This document should be listed in it, and the class of privilege which is claimed in respect of it should be established, right? And I think this can hold over to trial. What I believe, sir, that the document will establish is exactly the same point I wish to deploy via the EMA Saxoner report, and that is that at least well before October on the timeline, and what it must have been May, June, July, the claimant was again aware that the payments made to Mr. El Fadil were legitimate, had been processed in the proper way, and that the evidence which would prove them was right there in file 24 on their office wall. And that's the point, sir. And everything that I've taken you to, Mr. Jabra saying 7 times, I only found out in October, well, it'll be disproved by that evidence, sir.
Oh, right. Thank you very much. Now, Mr. Montague-Smith, let's take these in order.
Thank you.
The electronic copy of the MS Word and Excel files, which constitute the documents at blah, 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 the internal audit report. What do you say about that?
So, as I understand it, the Excel file has been provided, and we will search for the MS Word file, and if we find it, we shall produce it. Yes. That would be one of the things we refer to in the document production statement.
Right. Thank you. That's enough. And what do you say about B?
I don't know what is in that file. I've got no idea. What I say about B is that it's extremely late in the day for the claim to the defendant to be making these sorts of applications. There was a document production process that was gone through, and here we are 6 weeks before trial, and we just don't know what the size of that file is. It may be 1,000 documents, maybe 20 documents.
I want you please to look at that file, your team to look at the file.
If we can find it, Your Honour.
Yes, so you've got to first take all reasonable steps to find it. Having found it, have a look at it and see if it is too much to ask at this stage, given the size of its contents and extent of its contents and so on, to be provided, or if that is not the case, that it is manageable to give production of that file, to give it.
Thank you. Will do. In relation to C,
Yeah.
My current understanding is that there are no documents and that the requests were made orally. But again, we're quite happy to make a search and provide for that in the document production.
Okay, good. Okay.
These have been provided.
Thank you very much, Mr. Montague-Smith.
Can I clarify, though, in relation to what the document production statement will contain? Because I think my learned friend is misunderstanding that there's no general obligation for disclosure in this jurisdiction.
No.
It's the IBA approach. So documents
Yes.
which my client does not rely on, and documents which aren't responsive to a request or one of the orders that Your Honour has just made, will not appear on that schedule.
No. No. Well, yeah, I think that you're quite correct in what you say about that. All right, now, Mr. Bowden, so you've got your orders.
Yes.
You've heard what I've said, and there'll be a transcript of what's taken place today. Now,
sorry, Your Honour, to cut across you. I haven't addressed the KPMG report.
No. Oh, yeah, I beg your pardon. I missed that. Oh, of course, that's down in little 5. Do forgive me, Mr. Montague-Smith.
Not at all.
What do you say about KPMG report?
There is concern about how the existence of a KPMG report was discovered. You've read what Mr. Bowden has said about his current representation.
Yes.
He is to having had a conversation about the case with a partner who acted on behalf of the claimant. I'm not accusing Mr. Bowden of any discrete offence, but it is the rules about conflicts of interest are not just there to prevent actual conflicts. They are there to keep the reputation of the legal profession and the legal process in high regard. And it is just, frankly, unacceptable for an individual to move to the firm which was previously representing the opponent in the litigation and to have conversations about the case with partners who were working on the case. Now, would
you like me to respond to that now, sir?
No, please.
There is a general concern that arises in relation to that, but we'll put that to one side. This is plainly a document which is subject to litigation privilege. I don't know whether Your Honour recalls the decisions in the Court of Appeal in England where they looked at the question of whether or not the court could order production of an expert report which was not being relied on. I provided those two authorities, one called Edwards Tubb and one called Vasiliou and Hadji Georgiou. And the point there were that the Court of Appeal found that there's no facility for the court. They actually said it's beyond belief that the judge could have thought that these were disclosable documents as a rule, because the complaint was that the judge had cut across privilege by ordering their disclosure. And the Court of Appeal said, well, every judge knows that expert reports produced in the context of litigation are subject to legal professional privilege. And the point that was made there was that in one of the cases, the order for permission to rely on expert evidence had been specific and had identified the expert. So when the party wanted to change experts, they needed permission to do that. And so the court said, well, now we are in the position to say, we'll give you that permission, but only on condition that you reveal what was in the previous expert report. And subsequent, and so in the original case, Vasiliou, the Court of Appeal said, well, actually, in that case, the permission that was given was general, and therefore they don't need our permission to change experts because it wasn't discrete to the expert, and therefore there is no facility. That was the word they used. No facility, no vehicle, sorry, by which the court could order production of that document because it's privileged. In the other case, it was different because there was a specific order identifying the expert. I can take you to those authorities if you like, but
well, I don't think that's necessary. It's going to be necessary. We'll see how we see how we go. I mean, at the moment, it strikes me that if the KPMG report was obtained after proceedings had been begun, then it would clearly be a privileged document.
It was. Well,
and so if that is the case, and I'll accept Mr. Montague Smith's assurance as to when the report was commissioned. If it was commissioned after the second set of proceedings, I think what happens is that there's a judgment in default of defence, and then an application to set that aside, and then we move to a situation where the points that the defendant would have wished to have made on the application to set aside the judgment can be made in his defence to the claim. That's a very rough paraphrase of how it happened. It seems to me that the key bit of litigation that would give rise to the privilege would be once the contest was really joined, and at the moment I think that would have been after the second action, which is the one that we're concerned with here.
I can't tell you off the top of my head whether it was produced in the first. It was produced for the purposes of the first action or the second action. I'm afraid I'm new to this case and I don't have the detail of that.
Yeah.
It seems to me that regardless, if it's produced for an action, then it's covered by privilege. It doesn't matter whether it's the action with which Your Honour is engaged at this precise point in time. A privileged document is not disclosable in some.
Well, as long as there was, yes, I think you're right. As long as there was there had clearly crystallised the distinct possibility of legal action, then I think you're right. If the report was commissioned in the light of that distinct possibility, whether it's the first action or the second action, the report will be privileged.
And just to give Your Honour some comfort on that, Your Honour will recall that part of your reasoning in setting aside the default judgment and in later judgments was that the action was taken hastily by the claimant, and indeed that was the case. There were proceedings in the court very early in the piece.
Yeah. Okay. Now, Mr. Bowden, before you've heard the view that I've expressed about privilege.
Yes.
Now, do you have anything you want to say in response before I reach final decision on the question?
Well, yes, most certainly, sir. I believe that any privilege asserted in respect of the KPMG document should be set out in this proposed document production statement, and the matter should be held over pending that. Because, and I've got two reasons for this, sir. Firstly, my learned friend presupposes that any privilege in relation to this case still exists. I say no, sir. The second witness statement of Mr. Beckley, or the reply witness statement of Mr. Beckley in particular, relies almost entirely, sir, upon the advice that it received from its lawyers. And if we just go, sir, to document number 23 in the bundle there, sir, section 6, document 23.
Yes, I've read this.
Yeah, well, you can't have your cake and eat it. Now, if they are relying upon the advice that they obtained from their lawyers, how then can they maintain? Well, I'm interested to know, sir, because I don't understand it, and it hasn't been explained to me by my learned friend. And it really needs to be explained to the court by him. How then this litigation privilege is ever maintained in relation to this report? The second point, sir, is that privilege is exactly that. It's a privilege, and it does not shield liars, in effect, sir. So if they say, and I've taken you to the 7 reliances that Mr. Jabira has placed upon getting this material in October. If there is a document which directly contradicts what Mr. Jabira is saying, well, it's not privilege, sir. That's the basis of the objection. It goes right to the heart of what privilege is, and privilege is not there to protect people in this situation. And then just in relation to anything that I might have been said to have done, sir, I say that this claimant has been well aware of my employment at BSA. It's one of the biggest law firms in town, sir. And it has been aware all year, and that it is only and when I wrote on the 6th of July seeking this KPMG report and asserting that no privilege existed, that this entirely retaliatory missive came back on the same day, saying, what are you doing? I answered that comprehensively, sir, on that very same
well,
evening.
I've seen that. I've seen all that.
Thank you.
Now, look,
Mr.
Bowden, I can shorten this. I think that I'm going to adjourn for a short period of days this question of privilege. I'd like some very short submissions from each of you on this question. I'm going to ask Mr. Montague Smith to identify when KPMG were commissioned, and I'd be grateful if he would repeat in concise form the submissions that he's made to me this morning, and you in turn. I only want a few paragraphs. You in turn will respond to Mr. Montague's Smith's submissions, and then I'll come to a view.
Thank you.
All right.
May I just ask one thing? What
Yes.
we heard is an assertion of waiver. So it's being said that privilege has been waived effectively.
That's what's one of the points.
Yeah, I say it's incoherent, but I ought to see how it's put before I can answer that.
Oh yes, it's well, at the moment it's put on the basis that since there was reliance on the advice about going ahead and getting a default judgment, that that extinguishes the reach of any litigation privilege that would otherwise would have arisen.
Right.
That's what's put. And I shall say nothing about that at this stage. I want to think about that. I've never heard that submission before, but that's not necessarily fatal to the submission.
There's quite a lot of law on waiver of privilege.
Well, I really do not. It would be quite disproportionate to start cranking out encyclopedias on privilege.
Yeah, I agree.
To me, a relatively straightforward point as to whether or not the disclosure of this advice as to going for default judgment means that all other pieces of advice which the clients may have had come in.
Yes, I mean, to be clear, it's not said that this is litigation. This is legal advice in this report. It's subject to litigation privilege on the basis that it's a document prepared in anticipation of legal proceedings. It's a different kind of privilege, but there we are. We shall see what's said. I think all I was asking for was an opportunity, if needed, and if it's not needed, I hope Your Honour can trust me not to do it, to put in a couple of pages in reply to the waiver point, if needed.
And by the waiver point, you mean what
the
we're just talking about?
That privilege has been waived, yeah.
Yeah. No, by all means, I'd like that addressed.
Thank you.
So
I say
where we are now then is that we dealt with document production, save only for number 5. And I'd like Mr. Bowden, I think you should go first in this. Because I think this waiver point is one where Mr. Montague-Smith is entitled to see how you put it before he makes his response. So, Mr. Bowden, you've got 7 days for your short, concise submissions. Mr. Montague-Smith, similarly.
Thank you.
This is not due for trial until when? Remind me. It's
30th of August.
when is it? The 30th of September.
30th of August.
The 30th of August.
Yeah, for 3 days.
I'd forgotten that.
Yeah.
All right. Well, I'm going to shorten that. You've got 5 days, each of you. And Mr. Bowden, as to we'll have your submissions in 5. We'll have Mr. Montague-Smith's submissions in 5. And any final response from you, Mr. Bowden, must be served within 3.
I've gotten used to turning around very fast submissions. My learned friend has been training me up. No problems.
Right. Good. Okay. Now, are there any other really material matters that that need to be raised in the nature of this hearing, a PTR?
Well, Your Honour, I had some observations about the trial timetable, and there's really, I think, 2 broad categories of problem that I perceive. The first is that we're going to have to try to get through 7 witnesses and quite a lot of material. And some fairly meaty submissions on law. Your Honour will recall, in particular, there is a big question about whether or not DIFC law, and indeed UA law, recognises a tort of malicious prosecution and abuse of process.
Yeah.
For example, there is also what might ultimately be a relatively important question about whether or not the new employment law changes the way in which the court approaches to a penalty. When it came in. There's going to be quite a few of those sort of substantial questions. My own concern is that 3 days is not going to be enough. Now, we've prepared a very tight timetable. My client, as I said at the outset, doesn't want this to go off for any substantial amount of time, but it did occur to me that if the parties in the court could find a time where we could have 4 days in September rather than 3 days at the end of August, it may not be possible, but Your Honour might find that is a safer way to do this. And I suspect, Your Honour, and certainly I, will be wrestling with time differences a little bit as well. Trying to find a full day in all of that, and for Your Honour to get proper help from the advocates, I was concerned about the timescale. It's not an application to adjourn. It's simply a question of whether or not it's easy to do, and if it is easy to do, whether it might make sense. I'm not talking about pushing it back by more than a month, certainly.
Yes. Now, just before I hear from Mr. Bowden, of course, in a case like this, there's going to be a reserved judgment, and the learning that is sought to be deployed on these questions can be deployed in the opening and closing written submissions that the court can take away and master them in the course of coming to the final judgment on a reserved basis. The important thing to have in mind is getting these witnesses done within 3 days. Now, Mr. Bowden, what do you say to the suggestion that we look to see whether 4 days can be found sometime in September that everyone can meet, your witnesses and so on? What do you say?
Well, I've got no real problems with it, sir. I can't go into October.
No.
that would be a problem.
No one's talking about that. Okay, well, look, Mather is still presiding over these proceedings within the DIFC court. She's heard this exchange. Nathan, would you be kind enough to investigate the possibility of a 4-day hearing coming on in September? We will all have a number of diary commitments which are going to have to be respected. Could you please provide those to Mather as soon as you can, both of you, and I will provide mine. And I'll ask Mather to send me in the first instance, and only to me, what the possibilities are, and we'll take it from there.
Thank you, Your Honour. In light of that, Your Honour probably doesn't want to reach too many detailed conclusions about trial timetables and so on. If Your Honour, though, had an immediate view on the main issue that's between us, I suppose there's two really. One is who should go first, and the other is should time be divided equally. I don't want to give you detailed submissions on that. You've had my skeleton.
Well, I think I don't know whether I'm fortunate or not to have had some considerable experience of these proceedings. But I don't want any lengthy oral openings.
No.
The pleadings are in. You'll have your written submissions. I think you can each have 20 minutes.
Understood. I think we provide for half an hour.
All right. We can shorten that to 20 minutes.
Yeah.
And the witness statements go straight in.
Yes.
As evidence in chief. Both of you are experienced advocates. We don't want long and wearying and round the houses cross-examination, short and sharp, directly to the point. Some witnesses will be longer than others. The two of you must do your best to agree times for the particular witnesses. If we could get all the witnesses done in the 3 days, then I'd hear no closing submissions at all. We'd just have the witnesses' evidence. It'll all be in a transcript. And then I'll set a timetable for closing written submissions. So I want you to concentrate on dividing up time for the witnesses. And then try and agree. And if you can't, I want your rival proposals as soon as possible on the timetable.
Thank you for that indication. That's very helpful. In terms of who should go first,
I think the defendant's got to go first here.
That was my thought.
Well,
what do you say, Mr. Bowden?
Well, I say, sir, that these people have made some very serious allegations of criminal conduct against the defendant, and that it doesn't matter that they now say, oh, it's may or appeared to be. I mean, those are just weasel words and intended to lower the standard of proof for them. What they should do, sir, they've made the allegations that he did all of these things, or that he appeared to have done all of these things, and they should get out and prove it, sir. And then I can cross-examine their witnesses, and let's see what's left of it at the end of that. Not much, I'm going to suggest. And so that is actually the proper way to go.
No. You drew up the balance sheet of the allegations that each side are making.
Mm-hmm.
On your side, you are making a series of very live allegations, very very pertinent allegations, including the malicious prosecution allegation. And my judgment is that you should go first.
And I accept it unreservedly, sir. No
problem. That's how it's going to be.
It'll be a pleasure.
And so, of course, you must bear that in mind when you draw up the timetable.
We will go back to that and endeavour to increase.
So far as the cost of this hearing is concerned, apart from a large premium being due to the presiding judge, who is supposedly on holiday at the moment, I will order that there'll be costs in the case in respect of this PTR.
Thank you, sir.
Understood. Thank you, Your Honour.
Only thing I would add, sir, is that my missing skeleton, I will put that on the bundle.
Yeah, by all
And-
means. Put it.
Yeah.
Make sure it gets onto the e-bundle. Yeah.
Yeah, and I'll go back, if I may, and I'll remark up in exactly the way that I've previously done, and I'm sure my learning friend will keep an eye on me, and just mark up those passages. So I won't make them an annexure to the opening submissions. They can stay where they are, sir, and they'll be able to be referred to from there.
Now, there is one thing that I was asked to deal with, and that is about Mr. Bowden having joined the firm that were acting for the plaintiff. What I'd like from you, Mr. Bowden, is not just simply a reference to the correspondence that's gone between the parties. I would like you to propose, if you like, a protocol which you will observe in the course of the litigation from now in. You may well have observed it already, but I want from you a proposed protocol which is designed to ensure that there can be no leakage of privileged or confidential information arising from the fact that you are a member of the firm that acted for the claimant. And I would like I'd like a short statement dealing with the steps you took from the outset when you joined the firm to ensure that there wouldn't be such leakage. I know this is raised in the correspondence, but I want one short, coherent document from you on that.
Absolutely, sir.
Now, on that, almost certainly on that basis, the trial will be able to proceed. I may have something to say in general and in respect of this particular matter later on, but it's not going to affect the trial.
Thank you.
Right. Thank you very much, both of you.
Thank you, sir.
Thank you for interrupting your holiday, Your Honour. Apologise for extending it.
Goodbye.
Thank you very much.